All right, good morning, everybody. We're shifted gears from a civil docket to criminal docket. We have several matters set for this morning. Set for 10:30 this morning is Laura Eileen Meisel. File number is 252291SD. The defendant is here with her lawyer, Mr. Nathan Taylor. Also present is Abby Stoll from the prosecuting attorney's office and Daniel Frazine, who drew this assignment for a screening report. I did have an opportunity to review everything this morning, actually last Friday and again this morning. Good morning, Mr. Taylor. What would you like me to know here?
Yes, thank you. She's 51 years old. She's married. Her and her husband have 4 adult children. One of them's here today. She's never been charged or arrested before.
That's not true.
What's that?
That's not true. When she was a kid, she had an A and B case back in the 90s when I was prosecutor, but
Okay, well, I'm sorry to misstate that then.
but it's a long time ago
Okay.
and it was a minor deal but yeah, it wouldn't probably show up anywhere except my memory.
Okay, I thought I'd looked online and I hadn't seen anything out of that, but
It was under her maiden name.
that makes sense. She reports no alcohol since her arrest, which was in early November, so that's about 4.5 months ago. She has completed a substance abuse assessment. She completed the victim impact panel, which I have the certificate for. She's been seen Rena Castle for CBT. She's seen her 13 or 14 times. She has been attending AA. I have the updated AA sheets here with 36 total meetings.
Where are you doing your meetings?
At the Carver Center in Three Rivers and at the Presbyterian Church.
Good for
Three
you.
Rivers.
As you probably know, a lot of my sobriety court folks are in the Carver Center regularly. There's some good people in there.
Yes,
Um,
Mary's my sponsor.
Who is?
Mary,
Mary's your sponsor too?
yes,
Oh, she's busy.
she is.
Well, that's a good sponsor. Good for you. 36 of those you've had? All right, very good.
Since, I know they addressed this fence issue in the PSI, but there's some pictures that were taken on scene here. And I'll show them to the court, but the first one that's a little bit further away, it shows tire tracks. But it doesn't, they go close to the fence, but it doesn't appear that they hit the fence because there's some snow still on the fence. And then there's another picture here up close to the fence that shows that the snow has been knocked off. So clearly the snow was knocked off after the tire tracks got close to the fence. I can show those to the court if you want to see them.
Sure. I was trying to figure this out. She lives on 6th Avenue Road. This was over on, who took the pictures?
The officer.
Oh, well, I don't show any damage really, other than maybe just, but yeah, she was, and it was cold and snowy and, did you see these?
Yeah.
Okay.
Show me.
All right. Thanks. Go ahead, Mr. Taylor.
So based on the 769.5 statute, the presumption of non-probation, I would ask that the court would only assess fines and costs. And considering the fact of how much she's already completed, I believe fines and costs would be appropriate. Based on the mitigating factors and not having damage to the fence, I would score her in the box A1. And I would ask that the court would impose the minimums of fines and costs and no jail with no further or no probation.
You guys are good at our guidelines, as good as anybody is, and there are only guidelines. They help us get a sense of it. Judge Welty actually created them maybe 30 years ago, but they do help us gauge the case. Along with other cases, the statutes have changed, and the one you just mentioned, that there's a presumption of no jail time in a drinking driving case if there is no accident. Daniel did the screening report, which is very good. She was pretty straight up about it. He did cut her some consideration because of the serious alcohol issues. He would have originally done a 24-month probation, but he was willing to do it in just 12, which could be done in 6. But you've already done many of the things that I would have directed you to do as a term of probation. Mr. Frazine, what else would you like me to know?
Well, I understand that there's for the presumption out there. I think with the driving, even though there wasn't a damage to the fence, going off the road like that, driving in someone else's yard, not being able to see it all out of her windshield because she didn't remove any of the snow, which easily could have ended up in her death or someone else's. And those are really terrible driving factors, as well as the extremely high BAC. I think it's real easy for the court to get around the presumption of fines and costs in this case. But I did give her credit, as the court mentioned, because she has taken this seriously. But I do think, in fairness to all those out there on the road and to what I think is a history of drinking, I think a term of probation, which, as the court mentioned, she could get done in 6 months. I think it's very fair to have her on there with some monitoring and just to make sure that she's doing well and help her reinforce that she should not be doing this kind of behavior going forward without taking away from what she's already done.
Well, she got a huge break having the matter reduced to impaired driving. So
And I do want to mention, I had missed a 145 to TRPD. The prosecutor showed me there was a
How
request
much?
for that 145.
Okay. Abby, what would you like me to know?
I would just add, Your Honor, that our office did try to contact the homeowner. We didn't hear back from her, so we're not asking for restitution to repair the fence. But other than that, I agree with Mr. Frazine's report, and I would ask the court to follow that recommendation.
Ms. Meisel, what would you like me to know?
Your Honor, that was a wake-up call for me. And it opened my eyes to what had been going on and that I needed help. And I'm seriously getting that help because I do not want to go back to that time.
Well, I got the impression that reading between the lines that you left your house in anger. Like the people at your house were mad at you because you were drunk and then you left. Was there some sort of I don't want to call it I'll call it a heated discussion when you left your house?
No, my husband and I have been arguing all weekend and we just weren't talking. So I left. I can't explain it.
All right. You were going to a friend's on Broadway Street?
Yes, Your Honor.
So you weren't exactly going in the right direction, but you were very drunk. You were driving around like somebody in the bumper cars. The call came in. It took a while for the police to get there. You went off the road. You never brushed the snow off your window. You were an unguided missile. I'm really glad you didn't hit somebody else. Even with the officers, they asked you on a scale of 1 to 10, how drunk do you think I am? You said you were a 5. I think you're about an 8.5, and acknowledged drinking about a half a fifth of tequila. And that may be about right. People often minimize how much they drank, but that certainly could get you up to this 192 level. So Daniel has lots of experience as a probation agent. He made this report in good faith. You've done everything that I've asked you to do, essentially. You've gone to get an assessment. You've done the victim impact panel. You're involved in AA. This accident occurred in November, which will tell you how crappy this season has been. It already had several inches of snow on the ground by November 9th. But you were dangerous. For all intents and purposes, you don't have any criminal record other than some I remember from when you were a kid. But that was 95 or 96. So we'll just assume you have none. There's a statute that Mr. Taylor addressed that says in a non-serious misdemeanor, there is a presumption that the judge will not order any jail time or probation. I don't have to like it, but that's what the law says. There's also a case called the People of Auburn Hills. I can't remember the defendant's name. I called the Auburn Hills case, which says there is a requirement that district judges sentence proportionally. I'm not really sure what that means. That proportionality is a big deal in circuit court, felonies with the guidelines. But I'm going to go with Daniel's assessment. I think you could use a short term of probation to ensure that you keep doing what you're doing. You've done it now because you had criminal charges hanging over your head. You don't have any charges pending, but I'd like to keep you on this path. I'm very pleased you've been plugged into AA. It's just down the street from your house. You're going to a couple of them. And you had done this, you had a long period of sobriety. But you never got arrested before. At least not for any of this, at least that we could find. But I am going to do a 12-month probation. I'm going to do 4 days jail credit 2, leaving 2 days to serve. And I'm going to defer those 2 days. You're not going to do any additional jail. I expect you to complete this probation in 6 months. I want you to keep doing everything you're doing. And if you do that, then I'll be confident that you're going to stay on that path. There's a $300 fine, $75 crime victims' rights fee, a $50 state minimum fee. Did she have a private assessment?
Yes.
Yes, she did. She did.
Or I'll cut that screening fee in half to $50. There is no attorney fee. $480 probation oversight fee, which could be reduced to $240, and $145 police reimbursement, and $32 for, oh, she's already
Sure
done
did
it.
the VIP.
She's all over it. Daniel's argument that there are reasons why this could have been determined to be a serious accident. You didn't do any damage to this fence, but you were driving with a very high blood alcohol. You hadn't taken the snow off your windshield. You couldn't see. You were driving very badly. And then when the officer got there, you were still driving very badly, bouncing off the curbs and that sort of thing. And you weren't on the way to Broadway. I don't know where you were going, and I don't know if you knew where you were going. So let's add that up. 300 plus 125 plus 50 plus 480 plus 145. That's it, $1,100. And if we take 240 off that, makes it 860. You did post a 2010% bond. So we have $180. The court keeps 10% of a 10% bond. $920 minus 240. $680 in the next 6 months. I think you can do that. All I really want you to do is continue with your substance abuse counseling assessment support groups. Drug and alcohol screens. You can't use any drugs or any alcohol while you're on this probation. You had a bond that says you can't do it. Now you have a probation. And I think this was a wake-up call for you, and I think you're taking it very seriously. But we're going to do 6 months worth of supervision. And I think you're going to be all right. Do you feel better?
I do, Your Honor, yes,
You sleep better?
yes.
Yeah, I ask all my sobriety court people that once. Now, this was November, we're now in March, so about 4 months, that's a good start. If we get through 6 months, you'll be 10 months sober. And that likelihood of that continuing will just go from there. So I want you to go out with Daniel. I don't expect you're gonna do that 2 deferred jail days, because I think you're gonna do everything I asked you to do. But you go with Daniel, and I wish you good luck. I don't expect to see you anymore.
I get those photos back too, right?
Yeah, you can have them. They're there in the pack.
They're
Yeah.
okay.
All right, Mr. Gibson, let's take your cases, and we'll start with Michael Marini.